All right. All right. Here we go. Boom. And now we're live on YouTube. Okay. Anyway, alright, let's get on. Alright, guys, this berserk in there, and it's that swamp bottom, it's that possum butt, you know what it is. We're going to do a little bit of dissecting of traffic codes and traffic enforcement, traffic court. You know, I dogged this sovereign citizen through the mud like nothing, and I shouldn't, because like I said, you know, if we work together, we could find a solution. But a lot of them methods that the sovereign citizens use, they just ain't gonna work out for you in court. So let's talk about some things that will. You know, a lot of people can't afford a lawyer, and in traffic court, you might not necessarily be afforded a free lawyer. And if you do get a free lawyer from the court, that lawyer, 9 times out of 10, gonna get you found guilty, because that's how he's getting paid. Okay? So a lot of people want to learn how to litigate themselves and go to court and learn how to do pro se to save a little money, but they're still getting their bottom drugged through the mud. So we're going to talk about that. To preserve the legitimacy of our courts and reduce unnecessary litigation, we propose not radicalism but methodical self-education, so individuals can lawfully and intelligently challenge citations that lack a clear victim or damage. We're going to talk about 10 strategic lawful ways that pro se or propria persona lawful ways citizens can prepare to contest victimless traffic infractions with integrity. Okay, tactics to get victimless citations dismissed without that sovereign retort that's automatically going to get you thrown out of court. If you use sovereign citizen retort, they're going to throw it out of court. They're going to be way less lenient on you, and they're going to slap you with all they can. Don't use that shit. You got to speak right. All right. When they give you a citation, look that damn code up. Look up what they're charging you with. Chances are he just give you a basic code, and there's subsets that he didn't even list. She didn't list. If they didn't list it, how are you going to build yourself a defense? You don't know exactly what you're trying to defend against. Due process. Look for exceptions, elements, and definitions that must be met. All right. Understand what the officer must prove. Demand proper jurisdiction, the legal kind. Okay. If you can prove that there's no subject matter or personal jurisdiction, send a dismissal, motion to dismiss. And 9 times out of 10, if your argument is fair and just and true, they'll dismiss it before you ever get to court. You want to try and stay out of court. You know, look up refusal for cause. You can write that on a traffic infraction the moment you get it and send it back. You mail it right back to the officer. You know, you got to get a couple copies, certify letter it, mail it back to the officer, and wait about a week or 2, and then call the court and ask them to look up the citation number. Chances are they'll ask you for the name. If they ask you for the name, shut your mouth and hang up. And go on the court docket and make sure it's not there, but 9 times out of 10 it won't be there, okay? Challenge if the court misclassifies your infraction as quasi-criminal without proper bias, okay? Basically, that means if you have a victimless traffic infraction, they're labeling it criminal, but they're charging you as civil, all while charging you as criminal. It's lack of due process. Request discovery very early. Get every document that officer has as immediate. File a formal motion for discovery. Officer notes, dash cam footage, radar calibration logs, and training records. Many cases collapse when discovery isn't produced. Subpoena the officer. If the officer fails to appear, request immediate dismissal. If you go to court and that cop ain't there, dismissed. Don't let the state attorney try to act as a prosecutor, okay? He can't be prosecutor. He can't be the trier of the facts and the witness at the same time. Cannot do that, okay? That goes against federal civil procedure 12B6, which also follows with criminal procedure, okay? If they appear, question them on their training. Study the training manual for a second-class radio operator's license. That'll give you a lot of the questions that you can ask that officer on the spot. He ain't going to have the manual, and 9 times out of 10, he can't answer none of the damn questions. And if he can't answer them questions, right there tells you that he might not be able to use it. And any shadow of a doubt is more shadow of a doubt that you need. Because with traffic court, they only need 50% of certainty that he was right. It means burden of proof is on you, guaranteed, 100%. You have to prove that 50% is bullshit. That's on you. It's on you to prove the burden of truth, okay? Question him on his observation methods. Memorize every detail about that day, and then question him on those details. 9 times out of 10, he didn't write shit down. Okay? Get multiple continuances so that way he can lose his memory. Check him on his consistency of testimony. All right? So he's going to testify, and immediately after testifying, cross-examine him, go through a bunch of questions, and then at the end, give him 5 to 10 questions about his testimony and see if he can recall that stuff. Okay? You need to learn courtroom procedure. Practice your tone, your questions, and objections, the way that you're going to word things. You know, it may be funny, but use Chat GPT to do scenario back and forth. You know, have them act like the judge or an attorney prosecuting you on a specific type of case, so you can learn how to speak back and answer questions properly. You need to know when to motion for dismissal or suppression of evidence. Okay? Understand hearsay, foundation, and burden of proofs. Challenge lack of corpus delicti, victimless traffic infraction. Politely assert, Sir, Your Honor, if it may please the court, there is no injured party, property, or damage or breach of peace. Without a corpus delicti, how can a penalty be justified? This is not a sovereign theory. It's a valid question of harm and standing. File a motion to dismiss for lack of prosecution. If discovery is incomplete or deadlines aren't met, move to dismiss for procedural failure. Courts often prefer clean dockets over sloppy ones. Document every damn thing. Record dates, timings, filings, appearances, conversations. Keep copies of every submission. Mistake happen often. Practice cross-examine tactics. Like I said, use the chat AI to pretend to be a plaintiff or a witness on the stand or a judge or whoever and chat with them. You know, learn how to speak proper phrasing. Learn how to word each comment, each statement you're going to make correctly. Because you never want to answer, you want to answer with a yes or no, and then ask a follow-up with a question, or answer every question with a question. The objective is to keep the burden of proof on the plaintiff, so that way they're always fumbling, trying to figure out how to put the burden of proof back on you and find you guilty. If you keep the burden of proof shifted on the plaintiff, how can they find you guilty? You know, ask short, specific questions. Did you observe any danger created? Did you use radar? When was it last calibrated? Was it calibrated? When was it calibrated before you checked me, and when was it calibrated after? You know, it can't be but for so in a short window, and each state is different. Can you state under oath? Ask questions like, can you state under oath that no error could have occurred? You want to keep every question lawful and non-confrontational. Don't call the fucking officer a liar, none of that stuff. Don't cite fringe legal theories, Latin phrases out of context or I do not consent language. Judges respect citizens who use clear, fact-based legal challenges, not ideology. Okay? And regarding final thought, the court should not be burdened with litigating harmless infractions using criminal procedure, nor should citizens be made to feel like criminals or monetary missteps. Like and subscribe, and come back for part 2. You know what it is. It's berserkinarian. That's swamp bottom style. That possum. But the court should not be burdened with litigating harmless infractions using criminal procedure, nor should citizens be made to feel like criminals for momentary missteps without consequence. Let us return to a civil model for civil infractions, uphold fairness, and reserve the courtroom for matters that truly warrant judicial attention. Okay? Let us also empower citizens to challenge and properly handle citations peacefully and legally, and with a full understanding of your rights, not to escape responsibility, but to ensure justice is delivered in proportion to the infractions. I love it. Okay? Let's get right into it. 10 phrases that attorneys and police officers or executive officers use to lead a layman into a trap. Okay? So when you're standing there, objectively, these phrases are going to get you to admit guilt unknowingly, waive your rights, and miss objections. Okay? You do not want to miss your chance to object. That's your chance to say, whoa, back on up a minute. Okay? When they ask you, do you understand the charges against you? Saying yes can be construed as understanding and accepting jurisdiction. Instead, say, I comprehend the words, but I do not waive any rights or concede jurisdiction. Right? You're not challenging jurisdiction. You're just telling them that you're there, and you're not admitting that you understand the charges. You're just saying that you understand the phrase worded to you. Okay? They might ask, you were speeding according to my radar, is that correct? If you say yes, you just admitted guilt. Never affirm the allegations. Say something like, I don't believe I was speeding, and I would like to see the calibration and training logs. Or you could just say, I do not confirm, I do not admit or deny any allegations, and I would like to see the calibration and training logs, please. Do you plead guilty, not guilty, or no contest? If you say no contest, it waives your right to a trial and is treated the same as guilty. Plead not guilty unless you can cut a favorable deal. I would always say the proper thing that you would want to do is say, I do not intend to plead, I intend to answer in the form of a demur as such that does not acquiesce to quasi-jurisdictional court. But most states have done away with a demur, and basically a demur is you going, I don't agree with nothing you say, I'm not going to plead in any form, and I'm here by special appearance to answer your questions not admit to anything. Right? It's an old way of saying go F yourself. All right? It's an old way of saying I don't believe you have the right to have me here. Okay? They might ask, say something like, do you agree with the officer's version of events? You know, even any partial agreement can be used as collaboration. You know, you say, I can't agree without full disclosure of all evidence which have not been reviewed yet. Okay? You might say something like, you signed the ticket, so you agree to the charges. You know, signing the ticket is not an admission of guilt, but prosecutors try to apply it. And the ticket even tells you that it's not an admission of guilt. You just say, I signed to acknowledge receipt only, not guilt. You know, they might ask you, we can resolve this quickly if you just pay the fine. The trap is a waiver of your right to contest, often done without informing you of collateral consequences, points, insurance, and such. Always ask, will paying the fine be entered as a guilty plea? What are the long-term implications? Okay? You're not agreeing to anything, but you're asking a question instead. You know, there might be, this is just a routine traffic matter. And I heard the judge say that multiple times last time I was in court. The trap is meant to dissuade you from exercising your legal rights, okay? Your defense here is even minor infractions affect insurance, license, employment. Treat that shit seriously, okay? There's no need to subpoena the officer or request discovery. Why are you doing that? The trap is giving up your rights to challenge evidence and cross-examine. Insist on due process, discovery, cross-examine, and officer presence. Rights, okay, are rights. So the officer has to be there, and you have the right to cross-examine anything that comes out his damn mouth. So everything that comes out his mouth, make sure you write down so you can challenge it. And it gives you a chance to question him on operating a LiDAR, radar, or anything like that. You know, and challenge them right out the gate of motion to dismiss for lack of evidence if you don't put none of that information up there. I mean, how are you supposed to build a defense if there's nothing on it other than you were doing this, you were speeding in this zone on this day? Okay, well, how do you know that? You didn't put any information. That's lack of evidence. Maybe the judge will tell you this. The judge won't entertain your argument. That's trying to dissuade you and intimidate you from novel legal defenses. Respectfully insist, I'd like to preserve this for the record. Always get your argument on the record, especially when you're in an administrative court where it's a court of no record. Okay, you always tell them, I'd like everything I say put on record, please. And when you do that, it's preserving yourself for appealing a decision if you don't like it and you think that you need to appeal. Maybe they'll say, you don't need a lawyer for this kind of case. Well, technically it's true. They benefit when you're unprepared. Even a pro se persona, prepare like you're representing someone else. Always prepare. The better prepared you are, the better you're going to be. Okay? Here's 10 officer prosecutor mistakes that laymen often miss when you're running pro se, and you don't realize they've made mistakes or they're just bypassing things, and it's going to cost you to lose. Okay? Improper calibration records. All right? These are procedural, evidentiary, and strategic errors made routinely, but laymen often don't exploit them. Improper calibration records. Radar and LiDAR must be calibrated on the regular. Ask, may I see the certification and the date of the last calibration? You know, ask for the calibration prior to your citation and the calibration after your citation. How long is this officer going without calibrating? If the officer doesn't show up, motion to dismiss immediate. Right at the gate, don't argue nothing, just motion to dismiss. Many forget to demand officers present. You realize that your accuser has to be in court. You have to stand in front of your accuser. In many states, citations must be verified under oath. Ask, is the complaint signed under penalty of perjury? If it ain't, motion to dismiss. Failure to establish venue. Prosecutor must prove where the violation occurred. If they forget to state or prove it, move to dismiss. And a lot of people don't do that. But when he is telling the court where the violation, what violation is in front of the matter, where it happened, he must give absolute details, or there's issues with him being able to collaborate after the fact, because he can't enter in extra. All right, missing corpus delicti. There ain't no victim, no damage, or no danger. Where's the fundamental crime? Ask, where's the evidence of harm or public safety threat, please? Raise that issue. If you don't say something, it won't be something, okay? Improper use of hearsay, radar readings, dispatcher info, written logs are hearsay if officer can't testify to the origin. Objection, hearsay under proper foundation, unless proper foundation is laid, okay? Citation issued outside jurisdiction. City cops or unincorporated areas, or state cops off duty. Confirm jurisdiction with maps and badge records, okay? Incorrect citation code. Officers often citate the wrong subsection or leave fields blank. File a dismotion for defective charging equipment, okay? Like I said, maybe he put the code, but he didn't put a subsection at all. How do you know what to defend yourself against if the citation isn't properly filled out? You can't build a defense against something that's not there. No evidence submitted in the record. Many prosecutors speak about the citation but forget to formally submit it. If they don't enter it as evidence, move to dismiss after their case rests. Alright, y'all. So, part 2 of, methods to argue in court, fight traffic citations, We're going to go right back to where we left off. There's no evidence submitted into the record. Many prosecutors speak about the citation but forget to formally submit it. If they don't enter it as evidence, move to dismiss after their case rests. Pay attention. Prosecutors try to just through all the time, especially when people like you or I just stand up on our own and try to defend ourselves. They often just bypass many things because they don't think that you know this stuff, and they don't expect you to know anything, and they expect you to just blah, whatever, no big deal, and go on about your way. So look for things like that, okay? Make sure that the prosecutor's entering everything into evidence, all right? Procedural languages, okay? This is very important. Saying you clearly violated or posed a danger without evidence, okay? Objection to conclusions not supported by facts, okay? So if you're in there and, he was doing 94 and a 65, he was posing a clear danger, okay? Objection, Your Honor. No evidence. You just say, objection, Your Honor, to conclusions not supported by the facts. Okay? That's easy enough and simple enough. Don't let them get away with that stuff. You got to be careful. Due process violations that collapse a victimless traffic infraction case. Okay? Lack of notice. You must be given proper notice of charges, hearing date, and legal basis. All right? A lot of times a traffic infraction will tell you that you must appear to court but not give you a date. That's improper notice right there. Okay? File for dismissal. If vague or incomplete, motion to dismiss for lack of notice. Okay, I've actually done that, and I'm waiting to, and I never heard back on mine, but I assume since it's Friday and I have court Monday or Tuesday, they're not doing away with the motion, so I'm gonna have to fight it. All right. Lack of opportunity to be heard. Denial of your chance to cross-examine or present evidence is due process violation. So if the cop makes comments, you have a right to cross-examine. Okay? And when you're on the stand, you don't have to answer questions. You can plead the fifth. Okay? Just like these politicians and executives do in Congress. You know, you don't have to answer the question. You can plead the fifth. Okay? Alright. So improper service of summons. If citations or summons isn't properly served, court may not have jurisdiction. I don't know if you know this or not, but in civil and criminal procedure, the cop is not allowed to issue a summons. He's only able to deliver the summons. And every day, cops take traffic infractions and they issue a criminal summons without being a judge or a magistrate. It's a little unlawful. Alright? You have the right to no right to discovery. Denying discovery violates fair trial standards. You know, while you're standing there, if you didn't think about it before court case, while you're standing in there, as soon as the cop gets done yippee yapping, go ahead and motion, after you get done with cross-examining the police officer, go ahead and motion for discovery of all of his records, so that way you may see them before you continue forward. There's lots of things, okay? File a motion compelling discovery or a motion to dismiss if it's denied, okay? If the judge seems partial to the officer or prosecutor, request a change of venue or recusal. Ask the judge to recuse himself. If it seems like he's clearly going to make sure everyone is found guilty, which I've seen very nice judges, and I noticed that last time I was in court. Everyone that went in front of that judge, nobody got off without something. Everybody had to pay some form of fine, some form of cost of court fees, something. He was lenient on payment options, but you were going to pay something. Didn't matter. All right. No separation of power. Some jurisdictions use mayor or police affiliated staff to adjudicate infractions. All right. This court lacks independence, violating due process. Failure to prove every element. If the prosecution doesn't prove each required element of the statute, it's your duty to motion to dismiss. Administrative process misused as criminal. If handled in court of record without full criminal rights, argue quasi-criminal due process breach. All right. Unlawful stop or detainment. If the initial traffic stop was not based on reasonable suspicion, all evidence is fruit of the poisonous tree. Okay. Speedy trial rights are violated. Many jurisdictions impose timelines, 60 to 90 days for any traffic hearing. If it's seated, motion to dismiss for violation of the speedy trial. Okay. There's a lot that I went over in a short amount of time, but I want you to like and comment something you would like more into, because my next video is going to be more in depth by hearsay and traffic infractions. And we are, and I'm going to go more in depth on hearsay, because hearsay is something that people should definitely need to understand, because we need to work together to get our freedom back, but in the same aspect, we need to quit letting people like ill-informed, unintelligent, sovereign citizens that just spout off bullshit they see on a YouTube rabbit hole video. They're getting us in trouble in court, and we need to make some changes. So with that, stay stay tuned, like and subscribe and follow my next video on hearsay and traffic infractions. We're going to do a deep dive on it, and we're going to discuss what hearsay is, how to acknowledge it, how to catch it, and how to fight against it in court. You know what it is. It's Berserkinarian, the Swamp Bottom, that Possum Butt style, that Southern Hellbilly Deluxe. Follow me, like and subscribe. I love you. Peace out. Follow my series on TikTok. How to fight traffic courts, how to be a pro se litigant, so that way you're not spending all that money on lawyers, and how to defend yourself in court.
You know what it is, you're Berserkinarian, that's Swamp Bottom style, that Possum Butt. The courts
Y'all know what it is. I gotta go. I'll be back. I'm gonna start live streaming here in a few minutes, and when I get back, we're gonna do a live stream on hearsay.